Welcome back, everyone. This is the final session of the Saturday Florida Bar course on torts, and we have been putting in a lot of great work today. I feel like we have really beaten torts into the ground, and when I say beaten torts into the ground, I'm talking about assault and battery. So let's do some more learning and finish out today's session with a bang. I'm gonna make sure I don't do February 2010 and July 2006 because those are the assigned assignments. But let's check out February 2020. Hey, Alita, what's up? Nice to see you. I love people that exist in the real world. Did anyone take this test February 2020? No, I definitely taught when this test. I remember teaching for this test, and I remember it coming out and being like, "Oh yeah, that was my type of test." All right, Alita, you mind reading the first paragraph?
Sure. Rodney is a morning show host for WLAW, a radio station that broadcasts in Dade, Broward, and Palm Beach counties in South Florida. Rodney's regular weekday show is the top-rated radio show in the Tri-County area. 2 years ago, Becky, WLAW's station manager, rewarded Rodney with a 5-year contract that included a $150,000 yearly salary.
So off the bat, it's a contract essay, right? Is it need to be in writing? Yeah, 5-year contract, right?
Yeah, 5 years.
Yeah, it looks like we have a valid contract. All right. Despite Rodney's popularity, Becky frequently reprimanded Rodney about on-air statements or jokes that she thought were in bad taste. Rodney and Becky had a particularly heated confrontation after Rodney's show on Friday, June 1st. All right. Joel, you reading? Do you mind reading this paragraph?
Yeah. That weekend, the management of another radio station, WDEF, contacted Rodney. WDEF offered him a 3-year contract with a 50% higher salary and a $50,000 signing bonus. The offer required that Rodney start working for WDEF immediately. Rodney told WDEF that he wanted to accept the offer because he was frustrated with Becky, but he had a non-compete clause with his WLAW contract. The clause provided that for 3 years after leaving WLAW, Rodney could not work in any position for another radio or television station that broadcasted in Dade, Broward, or Palm Beach counties. Upon learning of the non-compete clause, WDEF's management told Rodney, "Sign the contract and we will let the lawyers sort it out. We want you on the air Monday." Rodney accepted, and on Monday, June 4th, he began broadcasting his show on WDEF.
Interesting. One thing that I'm thinking about is Dade County. It's actually Miami-Dade County. I think back in the day, they didn't like the name Dade. Now Dade has come back. Am I right about that, Alita? You're shaking your head? Anyone know the history of Dade County?
Yeah, I think it's Miami-Dade now. It used to be Dade, but now like the circuit courts now use Miami-Dade. Like I think it's just everything's Miami-Dade.
I think that's because Dade, who is named after, was canceled in some respects. I think. Could be making it up. All right, but let's talk about the class. I know more about the contracts than the gossip of Miami-Dade County. So we have a non-compete. Definitely, that's something we can talk about. It's got to be reasonable in geographic scope and subject matter and duration. It's a contract. What tort do we see? I might see intentional interference with a business relationship. The management of another radio station contracted him, you're poaching. I would call that poaching, but they would call it intentional interference with a business relationship. We have the non-compete clause. Let's see what else happens. Becky was stunned. To make matters worse, on June 5th, one of WLaw's largest advertisers notified Becky that it would no longer do business with WLaw because Rodney had left the station. Later that week, 2 other significant advertisers informed Becky that they were taking their business elsewhere and did not explain why. Although Becky had been in difficult negotiations with both accounts over the previous 2 months, she suspects that Rodney's departure was at least a partial motivation for the advertiser's decision. So I don't want you guys to have too much of a torts lens on, because this is obviously a contract question too. That's all getting to damages, right? And, breach of contract, right? Breach of contract, damages, and lost profits, whatever. Becky scrambled to find a replacement for Rodney. On June 8th, she hired Jack, another well-known radio personality in the area. Upon hearing the news that day, Rodney signed on to his Twitter account and wrote to the followers. It's always this. Jack thinks he can replace me on W Law. He's a total jerk. He drives drunk every weekend. What is that?
Slander per se.
Why?
Because it is, I guess it's crime of moral turpitude, but it also interferes with his business relationship.
Yeah, even before the business relationship, that's a crime of moral turpitude. You called me a drunk driver, right?
I'd also say defamation, no? Because it was published.
Yeah, defamation, slander is under the umbrella of defamation. I want you to understand that defamation includes slander and libel. Defamation is the umbrella that includes slander and libel. And here, why does it say he was convicted under 5 years ago? There may be some truth to this statement, right?
Okay, yeah, as a defense.
There may be some truth as a defense. Yeah. Excellent. So I told you, defamation comes up all the time. That slander per se comes up all the time. I really feel like the value of my course is the thoroughness in which I go through these essays to really demonstrate these are the things that are tested. These are the things we need to be prepared to look out for and write about. All right, so what do they talk about? It was a contract claim, breach of contract, right? Contract offers of his consideration, employment contracts at will. Like, I don't really want to get into the whole contracts thing. Consequential damages, non-compete, we talked about that. Non-compete, legitimate business interest. But then intentional interference with the business contract, I did mention that. They may also have a claim for intentional interference with business, existing contract. The defendant knew or had sufficient knowledge to know with reasonable certainty the contract existed, and there was an existing contract and interference with the contract that caused the party to breach, right? Loss foreseeable, tortious interference, higher salary paid, right? That's that tortious interference with a business relationship. We got to chill with that. Then defamation, a defamatory statement concerning the plaintiff, publication of that statement. A statement of fact that either on its face negatively reflects on the plaintiff, or where the statement would lead a reasonable person to infer a negative defamatory fact about the plaintiffs. Opinions are not actionable as defamatory statement. So again, defamation. Oh, he's public, right? We should talk about that. He's a public figure, so he would have to have actual malice, right? Truth is a complete defense of defamation, right? Truth, that's what we said. There is some truth, but it's not truthful anymore because he doesn't drive drunk every weekend. It's just 5 years ago. As a general rule, they need to be shown, but here we're talking about unless it's actionable per se, which we talked about. Here it was about his business. So that's what they said, business or employment. They could have gone 2 lanes here. I like what you did, Joel. I would have gone both, business and crime of moral turpitude. Now he's a public figure, so they also are going to have to show that's false, right? Malice. We're going to have to show actual malice, knowledge of its falsity, and disregard of the truth of its falsity. We do not know enough to determine, right? Like, we don't know if it's true or not. But then IIED, should have thought about that. Always a good claim for IIED. You know, it's likely that his tweet, it wouldn't have been outrageous. It was just a tweet. I mean, these days, if you could have an IIED for every tweet, like Trump, Musk, those people would be sitting in jail, or not jail, but they would be paying a lot of damages because they tweet wild stuff all the time about people. So like, how this plays out in real life is not the same as how we're going to write about in the essay. But do you see what I mentioned, that there's a lot of defamation that comes up. Just give me one moment to get back to the essay. There's a lot of defamation that comes up because it's a commonly tested thing. Anyone have any thoughts about that essay? Give me 1 second. I lost my spot here. Defamation, slander per se. A lot of you guys missed the intentional interference with the business relationship, right? But you won't miss it the next time. And then you also see how that one was a really good mixture of a contracts essay and a torts essay. Contracts still had to go through the formation of the contract, the non-compete, the breach, the damages, consequential, being foreseeable. You had to go through all that. But then on top of that, they wanted you to talk about actionable torts. So just something to take note of, that like we learn these subjects individually, but the way they're tested is togetherness. All right, anyone want to pick one for me? One that they like? A year? Someone seems to be missing. How about February 2019? Seems recent. What was I doing in February 19? Teaching the Florida bar exam. All right.
Is there any difference really in choosing more recent ones, or like when we're practicing on our own, I guess, in using?
I would start with the more recent ones because the model answers will have modern law. Like the law does change. So I've noticed that from the 2004, 2005 ones, there's some statements that are just objectively incorrect statements of law that were true before 2007 or whatever it may be. And then also, you know, you got to look at the Board of Bar Examiners as a growing entity. And so like you're talking about Messi probably, he's going to play this season more like he played last season than he did at the beginning of his career. So I would focus on the more recent ones. Then again, they're not very likely to test the exact same issues back to back year. So that could be like don't focus on last year's essays as like a factual thing. Focus on them more as like how they're written, and you know what length, you know what number of issues, you know, that type of thing. But yeah, I would say the last 5 years should be your bread and butter of like every single essay over the last 5 years you should cover thoroughly.
Did you order your essay, your essays that you wrote from the Florida bar to compare them?
Yeah, I did order them.
Yeah, that's a good thing to do. And you know, anything either of you noticed about your essays that you think already you can work on or improve upon?
I have not. I haven't gone through them yet.
Have you any chance? Anyone in the room have any chance to go through their essays and just for the group, what things maybe you know, truthfully and introspectively could improve on?
I only went through mine when I failed October 2020. But my writing isn't horrible, or it wasn't then, and I don't think it's horrible. So, and then since I passed February 2021, I didn't need to order them. So now I'm just thinking whether I should do it again, just so that I can see how I passed.
I think there's a value to ordering your essays because it's hard, you know, it's hard to look at your own tape and admit where you could improve upon, but it's the most important thing you could do, right? So like, you're the one taking it. I would recommend, if possible, people get their own essays, and certainly, you know, you could add that to the your accountability folder. That would be great for me to see. If anyone has ordered their essays, add your previous essays to the accountability folder so I can look through them and, you know, give you some feedback about what I think you need to improve upon. Because even when you do a practice essay under time circumstances, it's still not the same as when you do it in the convention center or whatever it may be. Anyone else have any thoughts? All right, I like this one. I can already see Paula slipping into the future. Prepare a memo that discusses the claims and defenses involved in Paula's proposed lawsuits against a supermarket. In the memo, include discussion of the ethical issues. this comes up a lot, right? So we're gonna have to put this puzzle together by February, which is torts plus ethics. That seems to be a very common essay, or contracts plus ethics. Like, just be able to have a very good canned ethics conversation. I usually write it first and then get right to it with the torts things. So anyone else hasn't mind reading, the first 2 paragraphs and telling me if they spot any issues? No one has to. Don't feel compelled. This isn't like the commandeering clause or anything.
I'll read it.
Thank you, Leah.
As part of its new marketing program, Supermarket offered a service that would deliver digital coupons to its customers' cell phones upon entering any of Supermarket stores. Paula registered for the service and used it often. Paula was shopping at Supermarket and received a message from Supermarket containing new coupons. As she walked down the frozen food aisle, she scrolled through the coupons on her phone. In looking at the coupons, Paula did not see a large puddle of melted ice cream in the aisle. Paula slipped on the puddle and her head hit the floor.
All right, let's talk about it. Supermarket's going down. Why? What'd they do?
Premises liability, negligence.
Yeah, they breached their duty to invitees.
With how? And in what ways?
Failure to. Sorry, go ahead.
No.
I was just gonna say failure to inspect, failure to.
You're talking about the puddle, right?
Yeah.
All right, but let's rewind. What else was negligent of them? Anyone? What else was negligent besides the puddle?
That they would deliver the messages as they entered the supermarket, maybe?
Yeah, negligent AF. Can anyone explain why that's negligent AF?
Because it causes them to be distracted as they're walking through the supermarket.
Of course, come on. You gotta look at the thing and then you like, come on. Even if it's not, remember, it's negligent not to put hot on a coffee. That's like, if anyone out here wants to be I don't want to use the term. If anyone out here wants to be a personal injury attorney, which I admire and respect, that's how you gotta think. Like, yeah, it was negligent AF. You want me to walk into the store and look at my phone and there's puddles on the ground and you're trying to kill me here? My
equivalent of texting and driving, but
it's like texting and driving. They made it texting and walking. I mean, it's kind of a corny test, right? These are corny situations, but they gave it to us. Okay, everyone is cool with that? Does anyone have any questions about that? Other than Joel and Alita, about why it was negligent to have the texting on the phones? No, we all get that? A large puddle of melted ice cream. Okay, what's interesting about melted ice cream?
Takes time.
Takes time, exactly. Time's on our side. That means that they probably had a duty to go through it, right?
To inspect or something.
Mm-hmm. Does anyone else mind reading this third paragraph?
Yeah, I could read it.
Good.
A supermarket employee arrived right after the fall and helped Paula to her feet. Paula said she felt dazed and asked the employee to call her husband, Harold, to drive her home. Harold arrived shortly thereafter and picked up Paula. While driving back to Paula and his house, Harold began typing a text message. While Harold was texting, the car swerved to the right and hit the curb, causing Paula to bang her head against the window.
Okay, so supermarket employee, what does that word always trigger?
Respondeat superior.
In my mind, yeah.
Right.
Help Paula to her feet. I almost want to talk about assault and battery there. I might just say it real quickly. I mean, did you grab her hand? You know what I mean? Helped her to her feet? I might just real quickly talk about assault and battery there, just very quickly. She felt dazed and asked the employee to call her husband, Harold, to drive her home. Harold arrived shortly thereafter and picked up Paula while driving back to his house. Harold began typing a text message. So Harold was negligent. I mean, that should trigger you to that this was negligent too. Because when he was texting, it swerved to the right. So when we're talking about contributory negligence, we're talking about intervening, supervening forces, right? we're talking about, I mean, is it his husband? There's no, you can sue your husband, right? We've abolished that interspousal immunity for tort law in Florida. Harold began typing a text message, right, and hit the curb, causing Paul to bang her head. Oh, the exacerbation of the injury. So yeah, what is supermarket liable for? Is it foreseeable that idiot husband was going to come and text his girlfriend while he was driving his wife? Like, maybe. After suffering headaches, Paula consulted a doctor, was diagnosed with severe concussion. She's been unable to work. This is getting at damages, lost income, medical expenses, now exceeds to recover. We're all cool with that. Let's see what they really got out here. Premise liability. So this is good. The issue is whether Paula may bring a cause of action for negligence under the theory of premise liability. That's even better than how I phrased it in mine. What did I say? Under premise liability, claim duty and independent care depending on the step. No, I said D has a potential cause of action against O for premise liability for negligence and failing to make the stairwell safe, thereby breaching the duty of care. They said the issue is whether Paula may bring a cause of action for negligence under the theory of premise liability when she suffered injuries to her head after falling in the store and for the injuries suffered as a result of the subsequent car collision. That's a great way to introduce premise liability into negligence, because you see it's like the same thing, but you want to use both terms. Negligence is duty, breach, causation, damages. To successfully breach a cause of action for negligence, she has the burden of establishing duty. Like, they wrote this one kind of exactly as I wrote the last one, but like better. Florida's abolished the distinction between licensees and invitees. I've kind of said that. It's hard to grasp, but that's why I keep saying there is a license invitee, and you always have the duty, a heightened duty of care, but they have the highest duty if they are business invitees. It's kind of convoluted, but like, I know, Leah, you're not loving this. I'm not loving it either, but that's my understanding of it, that they have abolished the distinction between invitees and licensees, and they're all owed that same duty of care. But then there's something that's called a licensed invitee, which is like a business invitee that has the even higher duty. So it's okay. We're getting points. We want to talk about licensees, invitees. Victims on the premises lawfully have not exceeded the scope of the invitation and are all classified as invitees, anyone who's not a trespasser. The duty to invitees is to keep the premises reasonably safe for the benefit of the invitee, to warn of latent or non-readily observable facts known to the landowner, and to make reasonable inspections and make safe any dangerous conditions on the land. Again, that's why this is the model answer, and mine was like, you know, not the best, but it was decent. But we'll see. This is time constraints. There's a lot that goes into it. This is a great so far. I love what they've done. Further, commercial business owners are owed a heightened duty of care to victims than residential commercial landlords are required. Business owners must also keep the premise free from any movably or transitory substances and any unreasonably dangerous artificial or natural conditions to any invitee in the property and others adjacent to the premises. I highly recommend reviewing February 2019 for premise liability. If you can just spit this out in these terms, I think this is new. It's 2019. They actually are right about this. I've alluded to this, that they have abolished the distinction, but like, they spoke about it properly, how there's still a heightened duty for commercial business owners. That's kind of what I was getting at, but this is more articulated. Here, slip and fall, foreseeable victim, they owe the duty, like, sure. The issue is whether they breached the duty as an invitee when she slipped and fell. As discussed above, they have a duty. Is not necessary that they had actual notice reasonable inspection. The rule is appropriate in the facts at hand because the supermarket aisle is full of transitory substances. They failed to make reasonable. It was long enough to melt, like we said. Furthermore, that they arrived right after the fall indicates that they were nearby and they could have made safe, right? That's a good point. Causation, but for here, the head injury occurred the act of slipping on the melting ice cream. Right? They did just like I did in this essay. They took a lot of time talking about the first, cause of action, breach, causation, damages, because then after that, it's see rule above, right? They talked about eggshell plaintiff theory. I like that. The husband's negligence in driving, substantial factor. Paula may be persuasive as mentioned. They're just getting at the whole negligence, the substantial factor, and the husband driving. They didn't talk about the looking at receipts as you walk in the door. That to me is negligent AF, but maybe they didn't talk about it. Comparative negligence, we talked about. Florida has pure comparative negligence. Florida has done away with implied assumption of risk. They may wish to assert it because she impliedly assumed the risk of looking at her phone while walking. However, this defense is unavailable. Comparative negligence is walking through the supermarket. Okay, and then they talk about remedies. Compensatory damages here. Supermarket incur full liability under joint and several liability, right? That's not right. That's incorrect. This is like, it got worse as it went on, but it started off really strong. What I'm noticing about the model answers is it's like they pick them for their first 3 paragraphs, right? These were really, really good paragraphs about premise liability. I would have also talked about how it was negligent to have this program knowing people are going to be looking at it while they're walking. They did duty breach, causation damages. It was all about slip and fall, premise liability, and then comparative negligence. Not a bad essay, but bad in the sense that if you don't know how to write about premise liability, it would have been a very bad essay. Anyone else out there have any thoughts about that premise liability essay? Who's out there? I don't want to call on anyone, but make sure that you're paying attention and we're doing this. I think honestly, just like in my MBE class, when I'm doing questions, that's the most valuable thing. This right here is the most valuable thing, to see live in the flesh, what are the issues being tested and to just get exposed to them. So let's try, let's go back in time, February 2004. Do we do this one? No. All right. Alita, you mind reading this one? Just the first 2 paragraphs?
Sure. While Jogger, a young and successful physical therapist, was running, she saw Dottie, owner's Dalmatian dog, standing on the public sidewalk in front of Jogger. Dottie had jumped the 4-foot fence that completely enclosed owner's yard. Jogger did not want to deviate from her route, and as she passed Dottie, she was attacked and bitten by the dog, causing lacerations requiring stitches. Immediately after the attack, owner drove up to his residence. Owner exclaimed truthfully, "Dottie and I have lived here for 5 years, and Dottie has never jumped that fence nor bitten anyone."
Perfect that you're reading this one. The owner of the bad dog herself, right? This is where you could go crazy on knowing the Florida dog rules. We've abolished the 1 bite rule. The dog has to have shown dangerous propensities. Having the bad dog sign would be good, but still, Dottie jumped the 4-foot fence and closed the owner's yard. Is that a trespassing claim?
No. Wait.
It's a discussion. Is that trespassing?
No, I think it's negligent to have a 4-foot fence. Isn't that short?
I mean, maybe we talk about it's a short little fence, but
and it's a Dalmatian dog. Like, those dogs are big.
No, but is it trespassing? If you throw a rock on someone's property, it's trespassing. If you're
but the dog is jumping out of its property onto this public sidewalk. Like,
okay, true. Standing on a public sidewalk, Dottie had jumped the 4-foot fence enclosing her yard. That again is negligent. Beautiful. Negligent to have a 4-foot fence and a Dalmatian dog. If you don't know anything about dogs, this is not obvious. But if you know anything about dogs, Dalmatians are pretty big. 4-foot fence is an easy jump for them. I like that. So Jogger did not want to deviate from her route, and as she passed Dottie, she was attacked and bitten by the dog. I kind of think that's interesting.
It's like an argument for assumption of risk, maybe.
100%. Like, you see this killer dog, you should probably deviate, Dottie, the killer Dalmatian. She was attacked and bitten by the dog, causing lacerations requiring stitches. Yeah, I was just thinking about 101 Dalmatians. Someone was recently telling me, like, if you think about the plot of that movie, it's really messed up. All right. Immediately after the attack, owner drove up to his residence. Owner explained truthfully, died an hour later. So that again was getting at the propensity 1 bite rule. All right, cool. Joel, you mind reading the second two paragraphs?
Sure. Okay. Owner drove jogger to hospital's emergency room. On the way to hospital, owner was involved in an accident caused by the negligence of both owner and a horseback rider. Jogger who was not wearing her seatbelt was thrown about in owner's car, and as a result suffered serious but non-life-threatening head injuries. Jogger was transported by ambulance to.
Let's stop with that one. So there's a lot there, right? Owner was involved in an accident caused by the negligence of both owner and a horseback rider. Jogger who was not wearing a seatbelt was thrown about in owner's car and suffered serious but not life-threatening injuries. So this jogger is having a rough day, right? Jogger got bit by a dog, and now he's having serious head injuries. The question here is going to be, wow, wrongful death, survivorship claim, respect to Dottie's attack on Jogger, defenses, and against hospital. This is a tough question. I mean, I don't think they tend to do this as much in 2022. I think this is more of a 2004 essay where they give you 5 questions. Now they tend to give you like 2 or 3 maybe. But still, this is literally what I was talking about earlier when I was explaining survivorship and wrongful death, right? The survivorship claim are going to be any of the claims that they have. And then it sounds like this guy's going down. It sounds like his bad day is about to get even worse. But when he dies, then you could have the wrongful death claim that the state could bring on behalf of his death. All right, yeah, continue with this one, Joel.
Sure. Jogger was transported by ambulance to hospital's emergency room, where she was treated by doctor, an employee of Hospital Inc. Doctor was intoxicated when he treated Jogger, and as a result of doctor's intoxication, he negligently treated Jogger. Doctor's treatment caused the deterioration of Jogger's condition and her health. Of her condition and her death, intestate. 2 weeks later, hospital had no reason to know of doctor's intoxication when he treated Jogger, nor any unfitness of doctor to practice medicine. That
last sentence is important because that talks about negligent hiring and negligent training and
no reason to know.
No reason to know. This is important because wow, this doctor's an idiot. Negligence, malpractice, he's going down. This was about a survivorship claim, right? You have a survivorship claim against the horseback rider, and you have a claim against the dog owner.
And the doctor, I was going to say the doctor being drunk probably would absolve the hospital from any kind of respondeat superior vicarious.
I would talk about it. Yeah. Exactly.
Yeah, to discuss.
A lot of issues here. Jogger experienced severe pain and suffering from her automobile injury.
So we say negligent hiring?
Yeah, but we said again, there's probably negligent hiring, but this sentence is important because they had no reason to know of intoxication nor any unfitness to practice medicine. So like, we'll talk about negligent hiring, but it'll probably be defeated because they had no reason to know of any unfitness to practice or of his intoxication. Probably happens more than you would think, huh? Jogger experienced severe pain and suffering from her automobile accident injuries in the 2 weeks preceding her death, right? That's survivor claim. Jogger was survived by her current husband, with whom she had a 6-year-old child. Well, they talked about dying intestines, so the husband's going to be the estate, and the estate bring the survivorship claim. The child could bring, the estate could bring the survivorship claim, and the child could also bring the wrongful death claim because now the child doesn't have a mother, and the child is suffering from the wrongful death of the mother. Husband can bring that claim too. But the child cannot bring the survivorship claim because the child is not the estate. The estate's the husband under Lord and Testament. Everyone following that?
It also says that the husband is the PR. So
it also says that the husband is the PR of the jogger's estate and retains your law to do these things. Now it gives us these statutes. No cause of action dies with the person. All causes of action survive and may be commenced, prosecuted, defended, and name the person. That's survivorship. When the death of a person is caused by a wrongful act, any person who would have been liable and damaged shall be liable and damaged in specified action. That's wrongful death. Wrongful death shall be brought by the decedent's personal representative, the PR, which shall recover for the benefit of the decedent's survivors the damages specified by this act, which are caused by resulting in death. Corporations are persons for the purpose of the Wrongful Death Act. So that question those statutes right there didn't really tell us anything we didn't know. Let's just kind of see how they went through this. The basic differences between the claims is that the Florida law permits the continuation of a lawsuit via the survival statute though the party successfully dies. The estate then carries forth the suit, and damages recovered may include medical expenses, loss of wages, loss of future earnings reduced to present value. A wrongful death action may be commenced to address a loss of life resulting from tortious conduct. So wrongful death is to address a loss of life, and then the survivorship claim is for medical expenses, loss of wages, loss of present value. Such is often dependent upon whether the deceased is single or married, a minor, has surviving parents or children, in terms of claims and award damages. Damages may include loss of consortium for husband and child, future earnings, medical expenses, funeral expenses, etc. That's what I was talking about, the child, loss of consortium. Husband, on behalf of estate and wife, should file wrongful death action against the hospital and doctor. Husband should also file suit under the survival statute against the owner and rider. See how we talked about that? Survivorship, owner and rider, wrongful death against hospital and doctor. I like doing this essay and having this discussion because this is one of those things where people could get smoked on, right? There are definitely people who take the Florida bar exam who don't know the difference between wrongful death and survivorship claim and would have nothing to write about here. So I like this being one of those, like, you know, lesser tested things that we can talk about. Everyone's going to write fine about assault and battery, but this is something that I want you to know about. Okay, the best claim can assert with respect to Dye's attack is one of strict liability. Look how quick these answers were. Florida law provides that a dog bite is strict liability for the owner, regardless of whether the dog had a propensity to bite or a history of biting viciousness. This is old law, right? We know that Florida has abolished the one bite rule, and it is important if whether they had a dangerous propensity. Strict liability when imposed for the first bite and any successive bite of the injury. That's been abolished. Owner's best offenses are that jogger was negligent because she had the last clear chance to avoid the dog by deviating a bit from her route, yet she assumed the risk was contributed to negligence and counted the dog willfully. Owner may also attempt to argue that along this negligence, she provoked the dog to bite her by running near dog. I'll say that. However, though both these offenses are adequate under Florida law, neither will be successful and all likelihood will be held strictly liable. Horrible statement in 2022, but we could write it way better. We would say Florida has abolished the one bite rule. Florida, if they knew the dog had dangerous propensities and they had, you know, a duty to encage it better. Also, it was likely negligent that they only had a 4-foot fence, and there's an argument for contributory negligence or assumption of risk when the dumb jogger ran to it. Those are the points that I would make here, but we're not looking at it for everything. Defenses that the owner may assert against the PR with respect to the car accident, Good Samaritan. Owner may claim that he may not be liable. So that Good Samaritan thing, I think that's another thing. Like, as I do these courses for 6 hours on one subject, I'm like, what can we really take away? One thing that we could take away from this class is we've seen the Good Samaritan laws come up a few times. Owner may claim that he should not be liable or his damage is reduced because he was rescuing the jogger. However, one may also argue that he had a duty to do so given he created the peril by his dog. His Good Samaritan defense will fail because Florida law provides that one may be liable for ordinary negligence in carrying out the rescue, not gross negligence. From the given facts, owner committed ordinary negligence in the car accident and therefore be held liable. He assumed a duty of care for jogger, breached that duty with his negligence, and was approximate actual cause and fact of the injury. Owner may also assert the offense of assumption of risk, contributory negligence under jogger, did not wear a seatbelt, right? And such provided under Florida law as raising a presumption of contributory negligence. Owner may argue that jogger's injury were not caused by the accident itself, but from the resulting impact, was thrown out of the owner's car and as a result suffered injuries. This may be viable defense for the purpose of reducing owner's liability damages. We'll talk about contributory negligence here. PR should assert a wrongful death claim. The issues of vicarious liability arise or respondent superior. They may sue the hospital for gross negligence. A reason why they would not be likely to be liable for a jogger's death and why it would not be appropriate is because the doctor's intoxication and resulting negligence was so substantial that it was a superseding/intervening cause which cuts off the liability of the owner. We're all good with that, right? For those people who are here, especially Joel and Alita, but for everyone else who's here who's paying attention, like, this is good stuff to reinforce that you're not going to get out of like a big old textbook. You know, you really need to go through the essays and see, okay, this is how they write these things. It shows that they did the background check, they assume the duty of care. It's also arguing they should be held to a higher standard, which makes this intoxication more aggravating circumstance. Hospital may argue that when the doctor treated the woman negligently while intoxicated, that constitutes intentional tort or gross misconduct, which should remove him from the scope of employment. Hospital is likely to succeed on these arguments. This is what I recommend. When you write your essays, get as quick as possible as you can about identifying the issues, writing the rules, so that you can spend a lot of time getting really creative. Like, here, this may have happened. If this would have argued this, or if we would have had these facts. Like, you want to give yourself as much time as possible in that hour to get points. So get your rules down and then start getting creative and just, shooting for the stars and writing as much as possible. But once that hour stops, move on to the next essay and make sure that you get your points there. So that was a good one for us to do. Don't worry, we're getting almost towards the end. Does anyone have any questions so far about those essays? May, are you still with us?
Yeah, I'm here.
All right, good. I'm just checking in. You've been relatively quiet. What do you think so far, May, about any of these issues? Any one of them sound difficult still? Defamation or premise liability or Good Samaritan laws or anything at all?
I think the premises liability has been the discussion has been helpful. I don't know that we've covered it with the essays, but something I struggle with on the MBE as well is the strict liability, like products liability, I mean.
Products liability.
Yeah, rules.
It's time for us to look at a products liability one. I appreciate that. Let's see. Shutters. We think that one's gonna be products liability. Power tools. Yeah, that sounds more products liability. I got a dog who's a crybaby liability. Okay. Let me just real quickly. Yeah, it's definitely. I was gonna look at the model answer, but I can figure out in 2 seconds that this is products liability. So, May, do you mind reading the first two paragraphs?
No, of course not. Okay. Penny has filed a complaint in your court. Below, please find a discussion of the variety of claims that Penny may bring against various parties in an action, the party's defense to such a claim, and the likely outcome of the case. The first issue to point out is procedural. First, it is noted that both Acme and Rentals... Wait, is this the answer? Do you want me to read the answer or the question?
I'm so sorry. I meant the question. My bad.
Okay. I was like, this is a strangely written question. Okay. Acme Products Inc., Acme, a Florida corporation, manufactures small power tools. One of its products is an electric-powered nail gun. Acme's regional sales manager calls on Basic Rentals, another Florida corporation which operates several outlets in Florida. Acme's sales manager tells Rentals president that Acme's nail gun is safe, dependable, affordable, durable, and can be used for nailing all types of wood and wood products. Rentals buys 50 of Acme's nail guns at $200 each and sends them to its outlets for rental.
Let's talk about that one.
Okay.
So they're a manufacturer, so we can definitely think of products liability here because you think of, manufacturers or designers. They have a nail gun which is safe, dependable, affordable, durable, and can be used for nailing all types of wood. What does that sound like?
Like a warranty? Or like a guarantee? Yeah.
Yeah, absolutely. It sounds like an express warranty, right? And it was made by it was made by Rentals president, Acme sales manager. So it's made by the Acme sales manager. So again, some sort of vicarious liability, right? Respondeat superior, some authority that made that statement. So we have what looks to be a products liability situation. We have a manufacturer and we have an express warranty, right? They buy 50 guns at $200 each and send them to its outlets for rental. So you might be thinking this is a contracts essay at the beginning, but we have a nail gun. Sounds like something pretty dangerous, right?
Yeah.
All right. Anything else you noticed from the first paragraph?
I mean, I was thinking of like contract stuff for the or like the purchase, but maybe that's not really.
I mean, it never hurts to think that, right? We only know it's probably not just because it says torts are here, but as you were reading it, certainly you should be thinking contracts, statute of frauds, $200 each, 50. Even me, I'm writing that in my essay. Like I would be tough for me not to write about statute of frauds when I see a contract for $10,000, I guess. No, that's not right. $1,000? No, $10,000. Okay. So let's go to the second paragraph. May you mind reading this one?
No, of course. All right. Penny wants to make a piece of furniture from Brazilian walnut, a very hard wood. She goes to the nearby Tampa, Florida store of rentals and she rents a nail gun manufactured by Acme. The nail gun sat on top of Acme's original shipping carton. The following statement was printed on the outside of the carton, suitable for nailing all types of wood and wood products. When Penny attempts to nail two pieces of wood together, the ejected nail from the nail gun fails to penetrate the wood, bounces backwards, and strikes Penny in the left eye, resulting in a total permanent loss of vision in that eye and partial permanent brain damage.
Okay. So, products liability, right?
Yeah.
This is what you said you want to talk about. How would you think about addressing this?
Well, I think one of the, or two of the things that come to mind is like, or three. One is whether there was any change to the nail gun from the moment it left Acme's control, because that might determine whether or not they have liability, and the same applies to rentals. Related to that is whether Penny was using the nail gun as it like in its intended use. Mm-hmm. And then I think the third thing is the warning that seems to like maybe helps Acme and rentals, or not, depending on whether she was using it correctly or not, or if there was some kind of like design defect in the nail gun.
There's definitely warning issues here, and there's definitely explicit warnings. There's representations, right, by the manager. Then there's this explicit warning right here that's on the outside of the carton that says suitable for nailing all types of woods and wood products, right? Brazilian walnut is a hard wood, seems to be all types of wood products. So we have that express warranty. Then I would also think about implied warranties, implied warranty of merchantability and implied warranty of fitness for a particular purpose. That would come up here. Like you said, it could be used for nailing all types of wood. You knew that this was the particular purpose that would be used for. And then, yeah, we have these damages, strict liability. So you're going to be strictly liable for these damages. Like you said, was it strict under their control? Is this going to be a design defect or manufacturing defect? You know, we would have to argue both of them. And then is it going to be a breach of warranty? And we'd argue it's a breach of express warranty and potentially a breach of the implied warranties. All right, you're doing great, May. I'll actually, do you mind reading this one too?
Sure. Penny retains an attorney and the attorney hires an expert. The expert expresses his opinion that the nail gun has a design defect that caused the nail to bounce off the hard wood. During discovery, it is revealed that the nail gun, when delivered to rentals by Acme, had a warning label that stated, "Danger, do not operate unless wearing protective eyewear." However, the nail gun used by Penny had been cleaned with a heavy-duty solvent designed for removing grease from restaurant equipment by an employee of rentals after a prior rental. As a result of this cleaning, the adhesive which attached the label to the nail gun dissolved, the warning label fell off and was not replaced or reattached.
Okay, now we have some new information. So there was a warning label, but it fell off, right? It fell off because of the employee. Okay, so what are we thinking of here?
Well, first, that maybe it well, there seems like it's a design defect, so Acme still probably is on the hook, but rentals is as well for getting rid of this warning, and maybe there's vicarious liability as well because for the employee cleaning the nail gun.
I like that word, vicarious liability, respondent superior, coming up a lot. And then another thing that comes up on every single essay we do, right? You said that there might be some comparative fault here, contributory negligence,
Yeah.
right? It would,
Yeah.
and Florida is a pure comparative fault state, so we'll say that. And then what did I always say? Whenever there's a products liability case, there's a what? A contemporaneous argument or negligence.
Negligence, yeah.
I have a whole bunch of negligence arguments here, right? It was negligent to design this thing so the warning label could fall off. It was negligent to wash this thing with these heavy duty, with these heavy duty instruments, knowing that this thing could happen, right? So those are some of the issues that I have right here. Anything else? Negligence, products liability, manufacture, or you said this would be a design defect, whether it was in their control, whether it deviated from what reasonable was. You talked about how intended use, right? Definitely this intended use to use for this purpose. And then we talked about how there's going to be some sort of contributory negligence on the fault of the employer, employee. And then I always said negligence is coming with products liability. All right, during discovery, it is further revealed that several months before the rent of the nail gun, Acme discovered that his nail gun would misfire when working with very hard wood, resulting in nail bouncing off the wood. Acme concluded that the risk to the public was small if the user of the nail gun wore protective eyewear. Okay, by the way, when they said wearing protective eyewear, that's potentially saying that this guy, the plaintiff, he had a contribution, right? Or he did something wrong by not wearing the eyewear. But again, he didn't see the logo. So we're going to say he's probably absolved from that because the warning, he didn't see the warning. So then it says they knew that it would result in nail bouncing off the wood. Acme concluded that the risk to the public was small if the user of the nail gun wore protective eyewear. They further conclude that the cost of recalling all of its nail guns or notifying purchasers about the misfiring or warning the public about the misfiring would have a major financial impact on Acme's profitability. They therefore took no action. What does that sound like?
I mean, that sounds like negligence.
But what kind of negligence? Ew, right? Gross negligence.
Yeah.
That sounds gross, right? Because what? You knew that this nail gun was gonna misfire? That's not like saying you knew that people might get a little bit colder wearing your jacket than they expected. This is saying that people are gonna have nails flying in their eyes. So you had a duty to notify purchasers, and the only reason you didn't was because of your profitability. This calls back to the last question when we were talking about Cruella de Vil, right? And the 101 Dalmatians. That's wanton. That's gross. So if it's so gross and wanton, what does that implicate? What could they receive besides just compensatory
punitive damages,
which may are limited to what in Florida?
3 times compensatory or $500,000, the higher of the two, right?
Right. And we talked about there's some scenarios where maybe that could even be it could even go higher if they were intoxicated or if it was against the elderly or the children or something like that. So we have a good essay here. May, this is what you wanted, right? Let's see how they, and I'm using 2023 terms because I don't know if it's he or she, so safest by saying they. Let's see how they answer the question. And you already started reading it a little bit. So the first issue is procedural. Is know that both Acme Rentals are Florida corporations, therefore they can be sued and defend suit in Florida. We didn't talk about this. We talked about torts today. We'll talk about procedural another time. Florida Penny. Oh, they also talked about important to note. See, that's my favorite word, my favorite phrase. It's important to note. Just I'm going to add this. It's important to know there's no joint and several liability in Florida. So if under particular claims such as negligence, the court finds both to be at fault, the party will only be able to recover against each party that which she is owed by that party based on the percentage of fault. That's not very well worded. This is also because Florida recognizes comparative pure negligence, which, right, they got those things out at the beginning, pure comparative negligence and abolishing joint and several liability. Furthermore, Judge, your court would likely allow this to present. Okay, I don't know what they're really talking about here. So then, breach of warranty. First claim Penny may bring may be a breach of warranty claim against Acme for stating that the packaging is suitable for nailing all types of wood and wood products. In fact, Acme knew many months before this was not true. An express warranty is a warranty that represents the basis of the bargain and describes the use of goods at issue. Here it is clear that Acme's statement is an express warranty to Penny, which she can see on the printouts of the card and pick, knowing that it was a very good, hard piece of wood that she had to work with and needing something to fit that need. So again, in addition, she may be able to bring implied warranty of merchantability or implied claim of warranty of fitness for a particular purpose, which she may bring against rentals as well. The implied warranty of merchantability states that when sold by a merchant, the product will work as intended. Here, the nail gun did not work correctly to put nails into wood. In addition, under the fitness for a particular purpose breach, which can only apply to rentals as involves the store having knowledge of certain facts discussed immediately now, the plaintiff must show that there's a particular purpose in which she needs the product and she expressed such a purpose. The person in the store knew of such a purpose and the product did not work for that purpose. Here, Penny will argue that she's told rentals that she needed a wood for certain Brazilian walnut, that they knew of it, they still gave her a gun that didn't work. However, they will have a valid defense to such claim. Per their knowledge, it did work for the specific purpose. In fact, rentals themselves, for any type of liability that Penny may recover, may well have a claim themselves for breach of express warranty or fraudulent misrepresentation of a product against Acme. Rental may bring this as a cross claim if both parties are part of the action. This person obviously has a background in civil procedure. They want to turn everything into a civil procedure discussion. If both parties are part of the suit, or additionally may bring a separate suit against Acme for indemnification for recovery or additional tort claims. Rental will not be able to use its claims it has against Acme, however, to avoid express warranty to Penny. When Rentals buys a product, they're expressly told the nail gun is safe and can be used for nailing all types of wood. This next thing, fraud, misrepresentation, I really thought about writing about, but I just didn't mention it. Rentals may have a cause of action for fraud or misrep, given that Acme knew of discrepancies but failed to warn, and in fact specifically stated the opposite to potential retailers. This came up at the end. This was a fraud misrep case because they knew that it didn't work, and then they represented that it was true. So not only was it a failure of a warranty, it amounted to fraud and misrep. We should have looked into that a little bit more. Third claim, negligence. You can always bring negligence. Florida punitive damages are capped for certain 3 times compensatory or 500,000. We talked about that. May be able to recover punitive on top of that because, like we said, they were super wanton and gross. Strict liability, products liability, this is what we paid the big bucks for. Penny may bring a claim against Rental or Acme under strict liability. Torts law has a particular category as it relates to product liability, which allows a plaintiff to recover against a retailer or manufacturer, any person in the stream of commerce chain, if certain circumstances are met. In order to show strict liability, a plaintiff must show that the party at issue was a merchant, that there was an unreasonably dangerous condition of the product, that the product was in the hands of the defendant, that it was in the defendant's control so that a third party would not be the one responsible for any damages or changes to the product, and that the plaintiff made a foreseeable use of the product. Beautiful, May. That right there is how you bring a products liability, strict liability claim. Circumstances are met. In order to show strict liability, plaintiff must show that the party at issue was a merchant, that there was an unreasonably dangerous condition of the product, that the product was in the hands of the defendant, that it was in the defendant's control so that a third party would not be the one responsible for any damage or change to the product, and that the plaintiff made a foreseeable use of the product. It could be a foreseeable use or misuse. So that's awesome. First, there's no doubt that both parties are merchants, and so the first prong is covered. The second requirement, that the product be unreasonably dangerous, can be met in a number of ways. First, there can be a manufacturing defect so that only the one particular product is defective. There can be a design defect so that all products are defective, or there can be a failure to warn. Here, manufacturing defect is not an issue. The issue here was a design defect and also the implication of warning about the protective eyewear. P will argue that there was a design defect and that there was a reasonable alternative design that Acme could have implemented. She has expert support to back up that assumption. Acme will defend that there was no reasonable alternative design since their cost analysis showed blah, blah, but Penny's going to prevail because these people were literally terrible monsters. However, Acme will argue that they warned by putting a notice of protective eyewear and therefore they are not liable. In addition, Acme will argue there's no way to remake the product for wood cutting without this issue. Penny will argue that failure to warn does not override a design defect, that there's a more plausible way to design the product. Here, Acme could have recalled all the products, right? This is the whole thing about how they didn't. So, however, the warning here just tells individuals to wear protective eyewear, not the risk of wearing such eyewear. So like, even though, yes, they had a warning to wear eyewear, and it wasn't their fault necessarily that the idiot scrubbed it off, they still would be liable because it said that there was still a risk for people who wore eyewear. Like, they still didn't tell you of all the risks associated. Finally, Penny will have to show that the product remained with the defendant's control in order to prevail. Acme will argue that here, in fact, the nail gun used by Penny was cleaned by an employee rental. Acme may argue that this was a rental facility and therefore it constantly left hands of the chain of commerce here. While a plausible argument, given that on discovery specific information came about the misfire, it would be hard for Acme to override the product liability claim by arguing this break in the chain of manufacture, but not impossible. Lastly, P will have a foreseeable use of the product. P used it for a specific purpose and therefore likely will prevail on this claim. Do you see how they did this? They told you what all the elements were of product's liability, and then they went through and did the analysis. They said, you know, one, it had to be merchants, no doubt they're merchants. Then it has to be design defect or manufacturing defect. Here's design defect. Then, you know, they'll argue that they have a defense, but that defense won't work. Finally, we have to show that it was in their control. It'll be in their control. And lastly, I don't know how they said finally and lastly, like they don't have a good concept about ending things, but lastly, and for note that ultimately, like they really just are like one of those movies that's always going to have another sequel. They must have had a foreseeable use, right? It was definitely foreseeable that she was going to hammer into this wood. Note that ultimately, even if they're found liable, they will be able to recover under indemnification, defend that it can sue Acme for indemnification. This is because for strict liability, the ultimate liability rests with the manufacturer, notwithstanding the fact that rental could be liable in a suit. Thus, if Acme and rental are both in the case, rental will file a cross-claim for indemnification. This person obviously was a practicing attorney or knows a lot about civil procedure because they're sprinkling that all in. Then they have a claim for battery. Again, we did this fast. We didn't mention it, but certainly a claim for battery, right? Intentional tort of battery because they might argue they intended to cause a harmful and offensive conduct by selling a product with a known defect for the nail to bounce off the wood. Like, again, probably not going to succeed, but a decent argument to make for battery. May, what did you think about that essay?
Yeah, this was helpful, and definitely that paragraph where they go through in the answer where they list the standard for like products liability was helpful.
Right, they give you all the elements and then they go, you know, they line by line and seeing if those elements are met. But did you see how that essay also did a phenomenal job of talking about implied warranties, express warranties, you know, comparative fault, and just like different ways of getting to claims and potentially prevailing in claims than just strict liability and the negligence one. So we just have a few minutes left. Let's just fly through one quick essay just to see what the issues are. Alita, what's your favorite year in the last 20 years? Okay. How about what did you graduate? I don't want to ask a lady that. What's up?
I graduated high school 2010, school 2020.
2010. Okay, that's fair. We're not supposed to do February 20, or we just did February 2010. Why don't we do the year I graduated high school? 2008. 2008. I wonder what the hit song was in 2008.
Britney Spears.
No, that was earlier. It was more like Lollipop. All right. So power pills, food supplement. Okay, so Betty went to a health food store
I already
and
did
asked,
this.
what's up?
Sorry. I already did this.
You did this one?
I did this, yeah. So,
All right. Well, let's not make it too repetitive for you. Let's do July 2016. Oh no. Sorry. February 2007. We didn't do this one. Right? Donna. Hot Donna. Anyone know what that's from? Hot Donna? That's my era. That 70s show. Like,
Madonna's.
from Eric Foreman. That was her name on the TV show, on the radio. It was Hot Donna. And then Eric got all jealous because like everyone was saying his girlfriend was hot. Anyway, walk down memory lane. So Donna attended an all-day seminar at a hotel. The day of the event, she arrived and the hotel was full. So she hurriedly packed her SUV, began to lock the vehicle. Later that day, Jimmy walked in. Sorry, I think I was getting feedback on your thing, Alita. Later that day, Jimmy walked in, and after trying the doors of several locked vehicles, he found Donna's SUV, and he found a set of keys to the vehicle. He started up the engine to exit the garage. While stopped at a light, he noticed a police car behind him, and he took off at high speed. While careening down a street, he ran into and severely injured a toddler. All right, this guy's going down for some crimes, but we have torts here too. Who was riding his bicycle. Mother, who just heard the screech, came rushing out the door to see the SUV. I'm so glad to end it on this. This is going to be that NIED claim, right? As a result of witnessing the accident, mother experienced occasional anxiety, Mother came to you for legal representation. Well, one thing important is, why did they mention that Jimmy was 15 and driving a car?
Underage, no permission, probably.
Negligent supervision.
And does it matter that he was 15? Because he was operating a vehicle that you were an
He was operating as an adult, like it was doing an
adult-like activity. That was why they mentioned that. So just so we see, 100%, pure comparative negligence. We're talking about negligent supervision. That was great. Like, they'll argue for vicarious liability, but it's probably going to be inappropriate because he's a grown kid. Negligent in leaving the SUV unlocked and the key box unlocked for sure. Negligent in chasing him through the streets, potentially. Comparative negligence. Negligent infliction, NIED. Someone who's a witnesses that causes a person injury to a person they share a close relationship with. That would be the best argument there. They're saying that they would have a hard time because they actually suffered physical injuries. But we said it could be anxiety or something like that. So right here, because he was a minor, he still had a duty of care of a reasonable adult because he was driving a car, an adult-like activity. That was what I mentioned. We flew through that, but like, there's always little points that you can get. Like they tell you 15-year-old driving a car for a reason, adult-like activity. They might even say a bright 12-year-old. Why is he bright? Because bright 12-year-olds know how to read. So he would have seen the warning. So this was a super thorough day, 6 hours of torts. You know what the assignment is, to do 2 torts essays. And then over winter break, I'm not going to see you for Christmas or New Year's. I want you all to review contracts, review torts. And then there's a week on the calendar specifically for you all to look ahead and start studying the subjects that we're going to see. And whatever subject you hate the most, that's the one I recommend you spend the most time with over break. I would say the hardest on the Florida bar for essay subjects is real property. And one that you probably don't know as well as you think you know, and you should know a little bit better, is family law. But, for everyone, there's differences and you'll figure it out. But this was amazing, a great session today. Good luck tomorrow for those of you who are rooting for Argentina or for France, but it was awesome to do this session, and thank you all so much. I'm gonna stop this recording.